Hi, good afternoon. This is Lee Howard from Diana T. Myers and Associates. It's July 6th, and thanks for participating in the COVID-19 Continuum of Care office hours. I'm excited because we have a guest presenter today, Cindy Daly from Regional Housing Legal Services. I have known Cindy since I began doing this work, and what I can tell you is that every meeting I've ever been in with Cindy, I learned something. So I'm excited to hear what she has to share with us today, and we are intending to cover the upcoming ending of the eviction moratorium. There are multiple dates that are relevant, not just July 11th, and Cindy's going to talk to us about some of those other dates, as well as provide us with some information about the rental assistance program that is being operated through PHFA. So with that, I'll turn it over to Cindy, and thanks for joining us.
Well, thank you. Thanks for having me. Wish I could be in person with all of you. I know we're all getting a little tired of these calls, but thanks for having me. And as Lee said, I'm with Regional Housing Legal Services. I met many of you when I was with the Housing Alliance, but for the last 3 years, I've been back at Regional Housing. So let me do a little bit of techno stuff here, see if I can make this work. And now I want to, let's see, minimize this and do that. All right, can you all see this in my PowerPoint? If anybody's unmuted, you can let me know.
Yeah, you're good to go, Cindy.
All right, good, thank you. Well, first I want to say again that I'm really not the expert at this. One of my limitations is I don't handle landlord-tenant cases. So any questions you have about the court process, I am not the person to ask. And I do have a slide at the end of how you can get in touch with your local legal aid office if you don't already know those folks. I have been participating in a lot of calls of legal aid attorneys discussing all that's going on around evictions. So I think I've got a fairly good handle on it. But again, this is like the 10,000 foot level. There are details that I probably can't answer. I will also say it's complicated. So let me tell you what I know, and then I'll be happy to take questions to the extent that I can answer them. For starters, Lee asked me about the governor's moratorium, which, as she said, will be ending July 11th. It's not quite as simple as being a moratorium. It's a moratorium on new eviction filings, that is filings after May 11th when it was announced, for non-payment of rent. Let me first say on the positive side, to the extent you deal with people in manufactured housing, mobile home parks, they are covered as well as traditional landlord-tenant arrangements. But as I said, there are a number of limitations to keep in place. So it's only for non-payment of rent. Suppose a landlord files a complaint for non-payment and something else like disruptive behavior or frequent violations of the lease or whatever else. Can that move ahead? Well, we're not really sure. I'm not sure, but I think that there's no real consensus of that, and may depend on what judge you get as to how they interpret it. Here's another tricky thing. The executive order, the governor's order, only stops the landlord's ability to send a notice to a tenant. So the Landlord-Tenant Act has a provision that says before filing a complaint, the landlord has to give notice to the tenant. I think, and I should have checked this morning, but I think it's for non-payment of rent, 15 days in the winter and 10 days in the summer or something. Don't quote me on the number of days, but has to give notice. The reason that the governor's order only applies to the notice provision has to do with separation of powers between the courts and the legislature/executive. So the courts have exclusive jurisdiction, the Supreme Court has exclusive jurisdiction over how the court system operates. And that includes setting time for hearings and issuing orders and such. So the only thing that the governor has the power to suspend is legislation, and the legislative part of the landlord-tenant process is what happens before you get to court, and that is the giving of the notice. Here's another complication. The law also says that the notice provision may be reduced or waived in a lease, and many written leases have actually waived that notice provision. So does the moratorium apply if there is no notice requirement in your lease? There's a difference of opinion on that. Right after the governor's order came out, it's called the Administrative Office of the Pennsylvania Courts. They issued a memo explaining the order, and they said it applies to all evictions. But a few weeks later, in a brief filed before the Supreme Court in a case that was challenging the order, the Attorney General explicitly said this only applies to notices. It does not apply in leases where there is no notice requirement. Now, the court has not ruled on any of that, but we in the legal aid community were quite disheartened by the Attorney General's provision. So the executive order is not as protective as one might think. Also, I have heard that some of the county courts are interpreting the word eviction as in no evictions prior to mean the final step, the order for possession, putting somebody out, as opposed to the initiation of the legal process, filing a complaint. So things do vary from county to county. Now, extended, and there are some advocates trying to get the governor to extend the moratorium. It will expire the end of this week. I wrote down Saturday or Monday because, frankly, I'm not sure whether courts accept filings over the weekend or not. So it does expire on Saturday is the 11th, right? Saturday is the 11th. If the court is accepting filings, electronic filings, then evictions could move forward then. But again, check your county, because some counties have their own moratorium. I put in parentheses, Philadelphia just extended theirs to September 2nd. So is that all clear? If you're clear on all, you think you're clear on all that, here's something else. The Federal CARES Act has its own moratorium, and they're anything but clear. So the first is that a tenant in a covered property cannot be evicted for non-payment of rent or fees before August 25th. Technically, the moratorium ends on July 25th, but it requires that there's a 30-day notice given to a tenant before starting an eviction, and you can't give the notice before the moratorium ends. So no eviction could be filed before August 25th. What's a covered property? It's defined as one, first of all, let me see, are these... Okay, no, okay. I was getting confused myself, and you'll see why in a minute. One that it participates in a federal subsidy program, and they're all enumerated. Actually, it's anything covered by the Violence Against Women Act and some other stuff. Or has a federally backed mortgage. An interesting question came up as to what participates in means. So if a tenant lives in a property that accepts Section 8 or housing choice vouchers, but that particular tenant does not have a voucher, can that tenant be evicted? There's only been one court, actually two court cases put out of the same court in Nebraska, as far as I'm aware. And it says, no, as long as that owner accepts vouchers, that all of the tenants are protected, whether or not the individual tenant is subsidized. This actually contravenes HUD's own what frequently asked questions, FAQs, where they say no, it's only the subsidized tenant. But the judge in that case took note of HUD's FAQs and said that they go against the clear language of the statute, which says any property owner who participates in a program. So it does seem as though a tenant living in a building that accepts Section 8 would also be covered. Now, the CARES Act has another section that has an indirect benefit protection for tenants, and that is the section that allows owners of multifamily property that have federally backed mortgages to apply for a mortgage forbearance. So the owner can't make the mortgage payments, they can apply for a forbearance, and if that's granted, then tenants may not be evicted during the forbearance period. And some new HUD guidance says that tenants must also be allowed to enter into payment agreements. So assuming a tenant is 3 or 4 months late, when the mortgage forbearance agreement ends, the tenant cannot be required to pay that full 4 months rent in a lump sum. They have to be given a chance to enter into a payment agreement. Tenants may not be charged late fees during that time and have to be given 30 days notice to quit at the end of the forbearance period. So again, this is all tied to the mortgage forbearance, excuse me. How do you know? Okay, wait a second. Let me go back here. I wrote in multifamily. There's also I thought, okay, I'll get to a single family in a minute. Comes up. This is confusing to me also. How do you know if a property is covered? It's really hard. So there are a number of databases, I'm going to show you something in a minute, that link to, give you a list of multifamily properties, subsidized multifamily properties. For a single family property, and I will show you that has its own kind of moratorium. It's very hard to know because while Fannie Mae, Freddie Mac, FHA have databases, you need the owner's social security number or tax identification number to access the information. And so really only the landlord can look it up. And because of how difficult it is to find out whether a property is covered, we've been asking, we meaning the legal aid community, have been asking local courts to have the landlord sign an affidavit that they're not covered. In other words, put the burden on the landlord to show that they are allowed to go forward with the eviction. So let me show you a couple of things. One is the National Housing Law Project. Let me back up. So I gave you a link here, and again, I'll send all this out. The National Housing Law Project homepage, you click on the coronavirus information, and it brings you to this, which is just a screenshot here. But in this paragraph, is a property covered by the federal moratorium? There are a number of links to databases of multifamily properties and other good information on this page. And then wait, let me see if I can escape out of here and bring up, this is, can you see, I hope you can see this now too, what we call the bench card that a legal aid attorney drew up for the magisterial district justices. It's sort of a cheat sheet, but it's also very useful for giving to landlords and to tenants to figure out if the landlord should be allowed to go forward with the case. And again, this refers to the CARES Act moratorium on evictions, doesn't cover the forbearance stuff. So it's complicated. I'm not going to read through it here. It gives the list of programs that are covered. and it gives the dates, and I will send this, and it has some links, and I will send this out also. So let me switch back to my PowerPoint and from current slide. Okay. Hopefully you can now see the PowerPoint again. So there is also a moratorium on FHA mortgages. Now these are covered under the CARES Act, but FHA extended it beyond the July 25th to August 31st. So no evictions until August 31st. What I'm not certain of at the moment is if then you need a 30-day notice after that. Interestingly, FHA did not limit the moratorium to non-payment cases, so all evictions are covered. It's not clear from what I read whether eviction means the initiation of the proceeding or the final step of putting somebody out. Fannie Mae and Freddie Mac also have moratoria on multifamily and single family, but they're different. So first of all, they also run through August 31st. So for multifamily, it's all dependent on whether the owner has a forbearance agreement. If yes, then as I described before, you can't evict tenants during the time that you're not making mortgage payments. If it's a single family property, whether it's owner occupied or the owner has turned around and rented it out, no evictions and no foreclosures until August 31st. So the most important thing, I think, is trying to bring the tenant whole, and the landlord for that matter. So moratoria are nice, but they end, and then the tenants owe money. So what we really need is to help the tenants pay their rent. First thing, and many of you are probably more familiar with this than I am, is your county may very well be using ESG money for rental assistance, what may be called homelessness prevention or rapid rehousing, but some form of rental assistance. They may also be using CDBG money or home money or coronavirus relief fund money, because there's a whole lot of money that came down from Washington over the last couple months, some with restrictions, some with not a whole lot of restrictions. So check with your county as to what they're offering. The other thing is that starting today, applications are being accepted on the new state-created rent relief program. It's administered by PHFA, but the applications are taken through the counties. And I gave you a website here, PHFA's website, where you can get all the information about the program, including a list of the county agencies. So it may be an Office of Housing, or they may have designated, say, to a community action agency or another nonprofit. So you need to know which county agency is taking the applications. You will find the applications online. The statute actually says that they must be able to be submitted online, but they're supposed to run through the counties. So really what you need to do is go to that county agency's website. And again, this is all new today. The guidelines came out 2 weeks ago. The guidelines have already been changed. We've been having a lot of conversations with PHFA. There are plenty of issues, and partly because the statute was so poorly written. I'm not going to get into all of them right now. A few of the highlights goes up to 100% of area median income, and PHFA kindly did all the calculations and posted the income limits by family size for each county. You have to be unemployed or have at least a loss of 30% of your income. Due to the pandemic, PHFA is saying after March 1st. They're not making people prove why they lost the income, but it's anything after March 1st. The assistance is for, I forgot to put in up to 6 months. Pay up to the full amount of the rent with a cap of $750. That's the way the statute reads. Now, the way PHFA has interpreted the statute is a little bit convoluted and also kind of gets around that 750 cap in some way, in some circumstances. They say that every named tenant, every lessee, can apply for assistance. So if you have 3 people sharing an apartment, maybe it's roommates and they're sharing a 3-bedroom apartment and they're each paying $600 a month, they can each apply for $600 a month. And as a unit, they would be getting $1,800. For reasons that boggle my mind, they count married couples as one tenant. And I've expressed to PHFA how ludicrous this is, but I won't go there right now. But if your client, family you're working with has more than a single head of household and has more than one named tenant not married, they can each apply. I did mention up to 6 months assistance, so that if you apply now in July and you are 3 months delinquent, PHFA will assume that you don't have, assuming you haven't gone back to work. I mean, that's a possibility. But if you're still out of work or you still have that loss of income, PHFA will assume that you need assistance going forward also. So it's a total of 6 months grant. That's what they tell us. It's not in writing. I mean, the 6 months is, but their assumption that you will need ongoing assistance, we have heard verbally, and I think that's what they'll do. They are not asking whether the applicant is a citizen. They are, however, asking for a Social Security number. That's what it says in the guidelines. Unofficially, they've also said an individual tax identification number, I think is what that is. Reason being, they are required by statute to run some of the names, but they're going to run all of the names through Department of Labor and Industries, Bureau of Unemployment Comp. They need Social Security numbers to do that. So there are a whole lot of issues that come up around undocumented people and whether they will in practice be able to apply, even though PHFA says they're eligible. There's a lot more with this program. Again, some things are still being worked out, but I urge you to familiarize yourself with the program. It opens today. I was listening on a webinar last Thursday, I guess it was, and someone from one of the counties said that will be administering the program said that they already had 10 applications waiting. So it's going to be very competitive. Get your clients in there. Tenants can apply, landlords can apply on behalf of the tenants. Landlords will need to, well, of course, the tenant has to consent, but even if the tenant applies, landlords will have to sign an affidavit with, let me think, saying that they accept the rent as payment in full, and that's going to be an issue in higher cost areas, and saying that the property meets housing quality standards, there will be no inspections, and that the landlord is current on taxes. Something else I was just thinking about that I didn't put in, a landlord has to certify. I don't know. There's a lot more. So we can get into some of that. If you if you can't remember all the details, just like I can't remember all the details, but basically, if you have clients who are being evicted, A, try to get them rental assistance, but B, you can refer them over to legal aid. Here's the website, palegalaid.net. When you, on the home page, scroll down to the button that says something about the Legal Aid Network. I don't know, I just missed it. Legal aid providers in PA, a yellow button. And it'll bring you to this page. So it's got an alphabet here and search by county. And then it'll bring you to your program. Of course, this is free, legal assistance. If you have other questions, feel free to get in touch with me. I may or may not be able to answer them. So that's my, let me stop presenting here somehow. And happy to take questions. I didn't totally confuse everyone or put everyone to sleep.
Neither, but I will say that I think this is so confusing. So thanks for running through this with us. The one question that I have is more of a confirmation than a question, which is related to the $750 maximum. I interpret your words and the PHFA language to say that this money cannot be coupled with another source. So
Thank
if you've got $1,000 rent and $750 from this source, can you add $250 from another source to make the tenant and landlord whole, or is it that the landlord has to waive, in this case, the other $250, or?
I'm so glad you asked. I'm so glad you asked that, Lee, because that is an important part. The statute requires the landlord to sign an affidavit that they are accepting PHFA's payment as payment in full. But what PHFA is saying is that before you apply for their program, check out those other programs, right? So if your rent is $1,000 and you got $300 in assistance from a county program, or I don't know, a charitable foundation or whatever, or a friend, if you got from, let's say, from a county program, you can still apply to PHFA for the remaining $700. You can't do it the other way around. So it is really important that first you ask the county what else they have, or what else is available within the county. And hopefully the county agencies, again, whether it's a governmental office or a nonprofit that's running the program for PHFA, will be aware of this and will guide the tenant to other programs first. But this is all happening so quickly. Oh, the other thing I didn't say, I'm sorry, I should have spent more time fleshing out the guidelines of the rent relief program, and I can add to the slides before I send them out. So this program, the applications start today. The last application will be taken on September 30th. This is Coronavirus Relief Fund money, which by Congress's decree has to be spent by December 30th. Somebody in Washington doesn't know that December has 31 days. By the state legislature's language has to be spent by November 30th, so that I guess they can figure out what hasn't been spent and have a month to do something about it. But the legislature specified that this rent relief program, and there is a comparable mortgage relief program, the last day for applications is September 30th. Applications have to be processed and checks have to be cut, and all that has to be done by November 30th. So it's basically a 3-month program. It's all happening very quickly. Some of the other programs may last longer. If it's ESG money, it has a longer time frame. But there's all a long way of getting back to your question that yes, you can couple it with other programs if you do it in the right order.
That's great, because I'm working on a document right now about that very idea of blending this money in the most, hopefully the most strategic way. So that's really helpful to know and understand. My second question is related to, you made a point, sort of a nuance at some point during the presentation about if someone has not yet regained employment. So if somebody lost their job March 1st, let's say, and went back to work July 1st and is 4 months behind in rent, March, April, May, June. Yeah, 4 months, which could be 5 because it's not like they start working and get paid immediately. So
right.
Here we are. My question, though, is did you say something that would preclude that individual from continuing to be eligible because they are now employed?
Well, I wouldn't say preclude. I would say that it adds a layer to the analysis. So here, there are two things that kick in if somebody goes back to work. First of all, the income limit for applying, 100% of area median income per family size is based on the date of application. Right. So depending on what their job was, if they're, working 20 hours a week at a restaurant, they might still be eligible. If, they had a professional job and were, furloughed for 3 months and now they're back at work, that's something else. So the first is the income limit. Are you eligible to apply? And then PHFA will take a look at your ability to pay your rent. Right. So you could qualify for the arrears, but PHFA could determine that you can now handle the rent going forward. But if you still are showing a loss of income, then they would make the assumption that you can't pay the rent going forward. And again, this is not set in stone because PHFA is kind of feeling their way as they go. This is what we've been told. I'm trying to think back as I'm talking to you what I actually saw in writing versus what I heard in comment or saw in emails, right? And so, so this is my best understanding of it, that if you are employed as of when you apply, you may still apply if you're income eligible, but you may or may not qualify for ongoing assistance.
Got it. So this feels kind of nuanced, but I'm going to ask anyway. Please feel free to tell me that this would be a question for, somebody actually on the county level administrating the program. I kind of have a feeling it's unfair to ask you this question, but using the same, I'm going to do it anyway. I'm sorry.
That's okay.
Using the same sort of scenario, I'm 4 months behind on my rent from March 1st to July 1st. And I'm eligible for a total of 6 months, and I can't yet afford my rent, let's say, of $750, but I'm expecting over the next couple months to be returning full-time instead of part-time, et cetera. Here's really what I want to know, which is, are people going to be sort of weeded out of the program if the assumption is if we give you 4 months back rent, you're not going to be able to afford the rent going forward? Yeah.
No, I think I know what you're talking about. It's like the current or the long-standing mortgage assistance program, HEMAP, has a requirement that you have to have, quote, reasonable prospects, and quote, of being able to resume your payment. There is no reasonable prospect test here. They got $175 million, at least 150 of it goes to rent assistance that they need to spend in 3 months worth of applications, and they want to spend it. So no, there is no requirement that you prove that you'll be able to resume your payments. From what I've heard, it might even be better if you can't. I don't know, but no, I don't think there's that requirement. Let me also comment. You made this statement that maybe it'd be better to ask at the county level. My understanding of the process will be the counties take the applications, they assemble the paperwork to make sure it's all there, the landlord's affidavit and any supporting documents that are required, and they send them all up to PHFA. The counties will not be approving applications. PHFA has to run it all past the Bureau of Unemployment, and then it's my understanding that PHFA will actually make the decisions.
That's really helpful to understand. Thank you. And I know you mentioned this in the presentation, and I think this is my last question. So for those of you who are on the call who may also want to ask questions, it's almost your turn. I'm sorry for just jumping right in. But you mentioned the Bureau of Labor and Statistics, or whatever they're running.
Unemployment, yeah.
Can you just talk for just a moment about, if you can, what the purpose of that is and what they're looking for, or how that impacts eligibility or whatever? Yeah.
So the statute that came in, it was like a 12th hour, back room dropped into the fiscal code thing, says that sets up two criteria for qualifying. One is that you've been unemployed. The other is that you've had at least a 30% reduction in income. And under the subparagraph about unemployed, it says the PHFA will verify unemployment through the Pennsylvania Department of Labor and Industries Bureau of Unemployment Compensation, or whatever the bureau is called. So PHFA has worked out an agreement with L&I, Labor and Industry, that once a week they're going to present a list of all the names and social security numbers of everyone who applies for the rent relief program. They're not even distinguishing between unemployed or 30% or reduction in income. Send it over to L&I, and L&I will run it through their unemployment claims and tell them who's getting compensation or who's filed a claim. Now, there are a lot of problems with the idea that you're going to be approved or not approved based on unemployment claims. So PHFA says, and I assume I'm not talking out of school by telling you this, PHFA says it's not determinative. They have to run the list, but if you're not on the list, you can still prove loss of income. Right? So whether it's 30% loss of income or total loss of income, they're required by statute to send the names over to L&I, but they will also accept other loss of income. And while I'm talking about loss of income, let me tell you something else that popped up that concerns me for a small subset of tenants. So the PHFA guidelines say that because they have to compare pre-COVID income with post-COVID income to see if you've actually lost at least 30% of your income, the tenant will have to provide proof of income for January and February of 2020, as well as March going forward. My concern and my comment to PHFA was for seasonal workers, like construction workers, they may not have had income in January or February, but anticipated significant income in the spring and summer. And so they really need to look at a full year's, at 2019's income. And the statute says annual household income. So I haven't gotten a response to that comment yet. I would say that if you have a client who's in that situation, be an advocate, work with the legal aid program, let me know, and let's see what we can do to move them forward.
Yeah, that's a great point. Thank you for that. I have another question, but I'm going to pause and let other folks jump in and ask away.
Make sure you unmute yourselves, folks, if you have a question.
Okay, well, they're thinking about their question or how to unmute. I'm going to ask another, which is, I believe you said unemployed or loss of 30% income, but then I thought you said and. So I just want to make sure that I'm clear if it's and or.
It's or. I'm sorry if I confused that. I guess my assumption is that in most cases, if you're unemployed, then you have at least 30% loss of income. But because of different household configurations, that may or may not. No, I mean that should work, right? Especially if you're applying as house. I don't know. Anyway, the answer is it's or.
Right. Okay. And then if nobody else jumps in with a question after I hit mute again. You and I were on a call together last week where it was being raised just a little bit about the requirement for a proper lease, an oral lease, a written agreement, a utility bill, none of these other sort of quote unquote proof of rental occupancy or a lease agreement would be accepted. I don't know if there's been any progress on that or if there's anything that you want to share about that, but I think that would be a good thing for folks to know and understand, especially as we start thinking through, we have a person in front of us, what is the best resource to match, if you will, with this individual, or if we're blending or braiding different resources, how to approach that?
That's a great question, and I'm happy to report that PHFA says they will accept oral leases and they are amending their guidelines. I haven't seen new language. I don't know exactly what proof they will accept, but that they will accept proof of an oral lease.
This is great. And for those of you who are on the phone, especially if you have clients that you're going to be referring to this program, or if your organization is one of the organizations that is going to be implementing and accepting the applications, or I should say packaging the applications. I think, Cindy mentioned reaching out to legal aid, and I think this is one of probably many examples of the benefit of doing that. The call Cindy and I were on included a representative from the Legal Aid Network who was talking about a few different things that they were looking to have amended about the program, and through their advocacy, this was changed. So, and most likely to the benefit of several folks that you all serve. So thank you for the work that you all have been doing on this. And I would just really like to encourage folks to reach out when you see these sorts of barriers that are impacting your client's ability to access these resources. As Cindy said, there's $150 million minimum for rental assistance to be expended within 3 months. So, let's see what we can do with this money and how we can really use it to prevent evictions, if, obviously prevent homelessness as well for folks, and make good use of these funds. I'm sure somebody else out there has questions other than me.
Well, and I'll throw a question out to the group. Do you see yourselves working with your clients? I mean, what are the typical clients? Do you anticipate problems with some of the guidelines that I've mentioned? I don't know, do you have issues about questions about how you will be helping people? So please contact me if any problems come up.
I'm also just curious if anybody on the line their organization is actually, facilitating or operating this program on the county level. And with today being the first day that you may have folks coming in, if you've already seen folks coming in or calling or whatever the process is locally for assistance.
Yeah, the married couple, so a comment here. Let me read this comment. I'm like you, I do not understand why a married couple is being penalized for being married. Tableland is facilitating in Somerset County. So yeah, interested in knowing what you're seeing already in terms of applications. I don't get the rhyme or reason for that language in the guideline, or that approach to it in the guidance. The statute, I believe, just talks about lessees, talks about household income. It talks about lessees applying, or lessee loss of income, and which is what PHFA is hanging its hat on, to say that basically roommates can apply individually because they're each lessees. My comment back to PHFA was husbands and wives are also individual lessees. It's not like on a deed where you take title as tenants in the entirety. It's not like the old days of the husband and wife are one, and that is the husband. On a lease, husband and wife are jointly and severally liable. So they're each liable for the whole thing. And very often, most cases, they're both working. So they can each have loss of income or be unemployed. I have no idea why they did it. Let's see. So you have one application in Somerset. Blair County Community Action is facilitating. Monroe County, we've contracted with Pocono Mountains United Way. Right, they were on the webinar, I heard. I know that in Schuylkill County, the Community Action Agency is handling it. Interesting. And are folks feeling prepared?
Yeah, I don't know how you could possibly feel fully prepared for what potentially may come through the door. The other thing I just want to say is that I know we've been talking a lot about the PHFA resources for good reason, but also just in reminding folks that the presentation started with the eviction moratorium ending and sort of the web of different timelines associated with that. Just wanting to make sure that folks feel like they have either the information that they need to best assist clients, or after receiving the few guidance documents that Cindy showed on her screen today, if you feel like you will be able to connect to those answers. If not, now's a great time to ask Cindy, who may be able to answer or direct us to the right folks. Okay, well, I don't want to unnecessarily keep you on the line, Cindy. I really appreciate your expertise today and the information that you've been able to provide. Let's see, there is a comment here. I'm a little concerned that the complexity of the application process may deter some landlords from applying.
Agreed. Hopefully, in most places, most landlords will feel like it's better than nothing. I know that people in high-cost areas, Southeast PA, but could also be, Lehigh Valley or Pittsburgh area or whatever, are very concerned about the $750 cap. The certification, luckily, PHFA says, that yes, the landlord has to sign the affidavit that the property meets housing quality standards, but there is no inspection. So I hope that doesn't scare people away. I'm concerned really that some tenants just won't be able to get hold of their landlord or get them to agree to participate. And I'm hoping that the county agencies become advocates in that regard and make phone calls and try to reach out to the landlords, but getting them to respond won't always be easy. I know before this statute was passed, before we had a program set up within the legal aid community, we were debating whether if we could get a program, a rent assistance program, is that an opportunity to impose requirements on a landlord? And while, you always want to see a landlord fix up a place or, not evict, agree not to evict for, I think that's also in there, that they can't evict for 60 days after the last payment, you don't want to turn away the most vulnerable tenants who are living in the most difficult situations. So it is what it is. We have to see how it plays out.
Yeah, that's certainly potential for another barrier there.
And again, that's a reason for looking at the ESG money or other. Each county also now has coronavirus relief fund money, which is unrestricted. It's quick. It's the money that has to be spent by November 30th. But the state received a substantial portion, They set up this rent relief program, the mortgage assistance program, and some other programs, and also sent money out to each county. So find out how your county is using its own CRF money.
Do you have any idea where the listing of how much money each county has and what's the point of contact? Or even is it the, a certain office in each county, or?
I'm not even sure that this money goes through DCED. I'm not certain, because unlike the other money, it has no program attached to it. It has no history, right? So it came from the federal treasury to the state treasury. It did not run through HUD or any other place, because it's not housing money. It's like for anything. And I don't know that it ran through a state agency. I think it may have gone from the state treasury to the counties. I don't know. County commissioners, somebody says, the county commissioners would know how their money's being spent.
That's great. That's another sort of local advocacy opportunity. That's great.
Yeah.
All right. Well, thank you to Cindy
Very
and
welcome.
everybody else who joined today. And we will, as Brendan said, we'll get the PowerPoint posted and the additional materials from Cindy. And if you have colleagues who missed today's presentation, Brendan will get the link out as well. And appreciate your time, Cindy, and everybody else's time today. Our next session will be in 2 weeks. Same time, same link, all of that. And if you have questions or related to evictions or the PHFA money or anything else, as always, you can submit those requests and we will try to address them on our next call. So thanks, everybody. Have a good afternoon.
Bye-bye.
Thank you. Thanks, Cindy.